Shelia Eddy, how do you plead to the offense of murder in the first degree of the felony charged in count 3 of the indictment in this case?
Guilty.
The record will reflect that the defendant has entered a plea of guilty to the offense of murder in the first degree of the felony charged in count 3 of the indictment in this case. You may be seated. Watch the chair, please. Well, what would the state have expected to prove in this case if it had gone to trial?
Your Honor, on the night of July 5th and 6th, 2012, Skylar Neese disappeared and was never seen alive again. At a trial, the state's evidence would prove that Skylar's disappearance and death were the result of a conspiracy between Shelia Eddy and Rachel Schoaf to rid themselves of their friend Skylar by killing her. They achieved their goal by planning to pick up Skylar from her residence after her evening of work had been completed. They planned to drive around, socialize some, and then stop at a location to smoke dope. Their scheme was to hide knives on their bodies and to attack Skylar at an agreed-upon moment. They even prepared by bringing a shovel with them to bury Skylar's body. Shelia Eddy and Rachel Schoaf carried out that plan. Together they stabbed and killed Skylar and left her body to nature. Shelia Eddy and Rachel Schoaf carried out that plan in conspiracy with each other and finalized that plan. As I have said, that would be our evidence, and that evidence in conjunction with Rachel Schoaf's evidence at trial regarding those events would combine with physical evidence to include Shelia Eddy's car, the vehicle that was used to transport Skylar that night, having the DNA of Skylar Neese in the form of blood on a part of the trunk of that car. We have also recently received a report from the FBI laboratory that shows that a vertebrae of Skylar that was collected from the scene of the murder shows evidence of injury that is consistent with having been caused by a knife blade. So with the physical evidence, the testimony of a co-defendant, and other testimony that would be part of a full trial, we believe that a jury would find beyond any reasonable doubt that this defendant is guilty as she has been indicted.
Thank you. Ms. Eddy, have you heard what the prosecutor said the state's evidence would be?
Yes, sir.
Is that substantially correct?
Yes, sir.
Is that what happened?
Yes, sir.
Ms. Eddy, are you entering a plea of guilty to the offense of murder in the first degree, the felony charged in count 3 of this indictment, because you are in fact guilty of this offense?
Yes, sir.
Mr. Benninger, before I accept your client's guilty plea, having consulted with your client, having investigated the case, and having heard the representations of the state with respect to its evidence, can you see any advantage to your client if this case proceeded to trial?
No. The reason for that, my conclusion, is based upon my investigation, which has co-extended with the full and complete discovery that we have requested and which we have been provided by the state, the federal government through the FBI, and the authorities in Pennsylvania who recovered and held the body and the remains of Skylar Neese. I have examined the law, the entire scope of the law here in West Virginia, under federal law and under the laws of the Commonwealth of Pennsylvania, to attempt to find a reasonable defense in law for my client. I have found none. I have looked at all the evidence. As the court's aware, we filed a number of pretrial motions, one or more of which was to suppress certain aspects of the state's case. We have thoughtfully, carefully, and in unison with with Shelia Eddy and her family have evaluated every piece of paper, literally every piece of paper, every video, every audio recording provided to us in discovery and pretrial proceedings. And I have found negligible, if any, factual basis upon which to develop a defense in this murder and conspiracy case.
So with that, the court is prepared to proceed to sentencing. Mr. Benninger, anything that you wish to offer by way of testimony, proffer, or statement before sentencing in this matter?
Yes, Your Honor, briefly.
Proceed.
On behalf of Shelia Eddy and in her right of allocution, I would state that while clearly understood by the court, the prosecuting attorney's office, and law enforcement, the silence which has surrounded these proceedings and our work in them should not be construed by the Neese family or any member of our community as a sign or expression of disrespect or as a sign of lack of remorse by Shelia Eddy and any member of her family, or as a sign of any lack of concern, worry, or caring by Shelia Eddy or any member of her family resulting from Skylar's death. The silence which has surrounded these proceedings was caused and insisted upon by me so that the work we needed to do on the defense was to preserve the integrity of the proceedings, the rights of Shelia Eddy, the rights of Rachel Schoaf, and most importantly, the rights of Skylar Neese and her family, so they could be protected without interference from the press, public opinion, or the statements and expressions made on the internet and in social media, which have been numerous. Now that we have come to this place and time in the proceeding, I can state without hesitation or reservation that all concerned must know and understand that Shelia Eddy, my client, and her family recognize that the Neese family is in a constant state of despair, loneliness, and sadness as a result of Skylar's death. For that, Shelia Eddy and her family are and will be eternally sorry. These proceedings are now coming to a close. With this conclusion, we hope that all families, the Neese family, most importantly, the Eddy family, and the Schoaf family, all tragically affected by the actions of Shelia and Rachel, resulting in Skylar's death, can move forward in a more peaceful and hopeful way.
Ms. Eddy, at this time, I would advise you of your right to allocution. That is your right to make any statement that you might wish the court to consider before it passes sentence in this matter. Do you have anything that you wish to say at this time?
Your Honor, I can, on behalf of my client, she asked that she be permitted to remain silent.
Skylar's aunt. Married Neese's sister. And you know what, I don't know what in the world would ever make somebody feel the need to have to kill someone in this world over anything. Nothing could be that tragedy that you couldn't work out without having to kill them. She's taken the hopes and dreams from my sister, from the prom to graduation to being a grandmother and planning a wedding. She'll never have any of this. And she's tore so many families apart that everything she gets coming to her, I feel is due to her. She came and she acted as if she knew nothing. She pretended like she was her friend and stayed and comforted us and swore she had no idea what was going on, and the whole time she knew. And to sit there and look at us and tell us she knew nothing, and now come to this day and she admits that she did, just shows how evil she can be. Thank you.
Thank you, Your Honor.
And again, sir, if you would just please identify yourself for the record, then you may speak.
My name is David Neese. I'm Skylar's father. I'm here today with my wife, Mary. I'm speaking to you on the behalf of my daughter because she can't be here. On July 6th, she made a decision to leave her house and go through a window and supposedly go with two friends, and I use that term. I'm sure you know what I mean. When we learned that she was missing, we immediately went to the Star City Police, who couldn't do anything with us, so they just listed her as a runaway. Since that date, my wife's life has drastically altered. We are no longer a family. The person sitting before you, Skylar's so-called friend, took her away from us without any remorse or feelings. You can look into the eyes of those who are responsible, but you can never hear what they heard as they were taking her life. You can see the faces of the killer, but you can't see Skylar's face. You can never understand the fear that she must have had as they took a knife and ended her life. You cannot imagine the pain that Skylar must have felt and the pain that Mary and I now feel. Your Honor, Skylar deserves to be heard today.
As I've said, and as you've heard very painfully from Mr. Neese, on the night of July 5th and 6th, 2012, Skylar Neese disappeared forever. It became known that Skylar had last been in the company of her two best friends. One of them, Shelia Eddy, had been friends with Skylar since grade school. The other, Rachel Shoaf, was a friend of more recent vintage. The investigation after that by police covered much ground and varying theories as to why Skylar had disappeared and how and when she might be found. Because Shelia Eddy and Rachel Shoaf were known to have been with Skylar on the night of July 5th, 2012, they were questioned by police a number of times during the ensuing months. They repeatedly claimed to have left Skylar at a location near her home and repeatedly disclaimed any further contact with her. Their agreed-upon story held up until late 2012, when Rachel Shoaf's story added a piece that Shelia Eddy's story had not caught up with yet. Skylar's remains, and mind you, not her body, but remains, were finally recovered in mid-January 2013. The reason for that was that on January 3rd, 2013, Rachel Shoaf finally agreed, after securing her own benefits, to tell the truth about Skylar's demise. She also drove with police on that date to show where Shelia Eddy and she had left Skylar's body that night in July. The truth that Rachel Shoaf disclosed about this horrific and vile crime included these things. Shelia Eddy and Rachel Shoaf had begun to distance themselves from Skylar. They had begun to fear that their friendship would dissolve. And if that were to happen, Shelia and Rachel worried that Skylar would divulge their secrets, the kind of secrets perhaps that girls have, and other things. The conflict grew between them over time, or at least in the minds of Rachel and Shelia. And during that time, Shelia and Rachel discussed methods of getting rid of Skylar. And then came the summer of 2012. After Shelia returned from a week at the beach in June of 2012, when Skylar had accompanied Sheila's family, Shelia told Rachel of her continual quarreling with Skylar during that trip at the beach. And the desire between Rachel and Shelia to rid themselves of Skylar intensified. So they made a plan to pick up Skylar after her work on July 5th, 2012, and to kill her. To carry out this plan, they armed themselves with kitchen knives concealed beneath their clothing. And they brought a shovel and clean clothing for themselves for when they were finished. After they picked up Skylar, they drove to a location with which they were familiar from prior times of driving around and smoking marijuana. After the three girls were all outside of the car, at an agreed-upon signal, a countdown actually, those two girls, Shelia and Rachel, both stabbed Skylar to death. They stabbed her multiple times. Skylar fought back and attempted to run, but she was overcome by her attackers. They stood over her until her last breath. Shelia, Eddy, and Rachel Schoaf tried to bury Skylar, but they couldn't dig into the hard earth at that time. So they left her body and tried to cover it up with tree branches and other natural debris that was around the site. They changed to clean, unbloody clothing and returned to their lives. These murderers, however, must now pay a price for their depraved actions. Today, we ask you to sentence Shelia Eddy to life in prison, acknowledging that under our law and under this plea agreement, she will become parole eligible. But we are asking you today, Your Honor, here today, to sentence this defendant to adult prison for her very adult crime. And we're asking that she not be returned to juvenile services custody, as is a prerogative of the court. I would remind you that if Shelia Eddy is now 18, she is no longer an actual juvenile, an actual underage offender. If she were to have committed a crime now at the age of 18 years, a crime of murder or even a lesser crime, she would go to adult jail and eventually adult prison. And that's what we're asking for today.
Nothing, Your Honor, except that I ask that you exercise your discretion in face of the request of the state that she be remanded to the adult jurisdiction of the Division of Corrections, that she be given the period of at least 1 month time period within which to remain in juvenile services custody before being transferred to adult jurisdiction. That's my only request. A very short period of 1 month. Obviously, you have the discretion to recommend a period until she's 21, but I believe the period of 1 month would give an appropriate time for humane adjustment to the eventual transfer to that system.
Very well. Ms. Eddy, would you please stand? Shelia Eddy, for your conviction of the offense of murder in the first degree upon your plea of guilty, it is the sentence of the court that you be imprisoned in the West Virginia State Penitentiary for the rest of your natural life, consistent with the requirements of the Constitution of the United States. That sentence is technically with mercy, which makes you eligible for parole after you have served 15 years. With respect to placement, it is the court's intention that the defendant be placed in the custody of the Department of Corrections as soon as a bed is available in a Department of Corrections facility. Just so everybody understands, it is the court's position that the defendant is not to be transferred into the regional jail system awaiting a bed at a Department of Corrections facility. Primarily because of the overcrowding that exists in the regional jail system. I think things are a little bit better in the juvenile side of house until there's a bed available. So it is the court's intention that you go into Department of Corrections custody as soon as there is a bed available in Department of Corrections. And I mean, if that's tomorrow, that's tomorrow. If it's 30 days from now, it's 30 days from now, or whatever it is. Until then, she'll remain in the juvenile facility.
To reveal and the court to know that under the terms of my retention as Ms. Shelia Eddy's counsel, I will remain her counsel for all post-conviction matters into the foreseeable future.
Very well.
Thank you.
Appreciate that. Thank you. Concludes the hearing.
All rise. Court's in recess. Please be seated.
Evidence was there to lead to that?
Well, when we talk about what our evidence would be at trial, we certainly start with the idea that if we go to trial, we believe in the justice of going to trial and believe that our evidence would be sufficient. And I truly do believe that our evidence would have been very sufficient to prove all of the counts of the indictment on the first-degree murder, as well as the taking and kidnapping of Skylar. With reference to what I said involving the expected testimony of the co-defendant, as well as the physical evidence of Skylar's DNA on the vehicle of Shelia Eddy, as well as the evidence from the FBI laboratory pertaining to the injury to the vertebrae which was found at the scene, which, as I said in the hearing, the evidence showed an injury to that part of Skylar that would be consistent with having been inflicted by a knife blade. So that, in addition to other witness testimony, we would, I believe, be confident of prevailing.
It seemed like this case was, at least from the outside looking in, difficult, a lot of investigation. How difficult was it to build the case to where you've reached this point today?
Well, in the days, weeks, and months immediately after Skylar's disappearance, the investigators were very confused as to whether Skylar had disappeared on her own, by her own volition. Certainly her parents did not believe that that was a possibility, but even though that was unlikely, police have to look at everything as a possibility. And so those efforts in the early days were to try to discount that and then to try to figure out what really did happen. Because the two best friends, as I said in the hearing, had claimed that they had left Skylar while still alive, while she was returning to her own residence, and disclaiming any contact after that point, that left a huge gap for police. At that time, because those girls were best friends with Skylar, police had little reason to disbelieve them. Even Dave and Mary would certainly not have believed that the best friends could have killed their daughter. So that was an obstacle in the beginning. But over time, as I indicated, those defendants were questioned repeatedly by police. Their stories hung together for a very long time, until late in 2012, when one of the girls, when Rachel Schoaf, added a component to her story that Sheila's story hadn't caught up with yet. And so it became apparent that there was much more to be learned from those defendants.
You talked about the secret. What were these secrets that these two girls had that they didn't want Skylar to know?
Well, it's a little bit difficult to know that for sure. Some references have been made to perhaps some involvement between Sheila and Rachel. I'm not sure about that. But it's also a little hard to get into the minds of teenage girls sometimes when you have an episode like this and a terrible outcome like this, where just everyday secrets seem like they would be life-altering if someone were to know things that girls share amongst themselves. So it could just be any number of things, and so that is what we believe ultimately happened, that the defendants were increasingly distancing themselves from Skylar, deciding they didn't want to be friends with Skylar anymore. Skylar was a drag on their relationship, and so instead of just saying, well, let's not call Skylar anymore, or let's not have Skylar on a sleepover anymore, let's kill her. And they did. I know for we ordinary people, in thinking about our daily lives, it's very difficult for us to wrap our minds around girls killing their friend. I mean, that's, thank goodness, something that's very rare. It just happened in this case.
Marsha, you just mentioned that this is something that is rare, and have you ever seen anything like this, and how do you respond to seeing something like this going on in the community where you live?
Well, thank goodness this is the first of its kind, of this specific kind of thing in our community. I guess the only other place you see it is in other news items or maybe in a Lifetime movie. It really is a rarity, thank goodness, but when you're confronted with it, it is a horrible reality. That will be scheduled, and if we can have our way, I think from my perspective, we would be able to schedule that as soon as possible. Of course, that will rely on the judge's calendar as well as the availability of Rachel Schoaf's attorneys.
Sure, as part of the plea agreement, the other jurisdictions agreed to this agreement. What kind of charges could Shelia have faced in those other jurisdictions?
Similar to the charges here. In the federal system, it would have been kidnapping charges because in this kind of situation, there isn't a federal charge for murder. And in Pennsylvania, their jurisdiction over a murder charge as well as kidnapping charges would be concurrent and similar to ours. As I recall it, and I'm going from my memory, the defendants were questioned separately on several different dates by the police investigators, and toward the end of 2012, Rachel changed her story a little bit in terms of where they had last seen Skylar and where they had left her, as opposed to saying that they had left Skylar in Star City, a block or less than a block away from her home when she was going to walk to her residence. She claimed that they had left her out in a distant part of the county, which also wasn't true, but it was a change from what she had said before, and a change from what Shelia Eddy had said during that very same time frame. And as you can imagine, ears perked up at that.
How early in an investigation did Eddy and Schoaf become the focus of the investigation? How early on did the investigators suspect they were somehow involved in this?
It was immediately known, and I would say, when I say immediately, I'm not sure if I'm saying hours or within a day or so. It was known that Shelia and Rachel were the last, thought to be the last people to have been with Skylar or to know where she was or had some contact with her. And that's because, for one thing, there was a surveillance camera at Skylar's place of residence. There was a camera on the corner of a building, and it could be seen that a car pulled up and Skylar left her residence and went and got in the car, and it was determined to be similar to the car that Sheila Eddy was driving, and then it was later confirmed by Miss Eddy that, in fact, that was her car, although she was a little iffy about that in the beginning. So I guess to finish up that answer, they were certainly, I'm not sure if it would be correct to say they were persons of interest in the very beginning, but they were certainly known to be people who knew where Skylar was last known to be seen and the people with whom Skylar was last known.
If you could even answer that, did you have a feeling you weren't getting the whole story? Did investigators
feel
that way?
Investigators covered a lot of ground, as I said. They talked to many, many people because I believe that there were theories that perhaps Skylar had somehow been given drugs and had overdosed, and people knew of that and weren't telling. There were theories like that that abounded, and that sort of had some legs because, as happens in a disappearance of a young girl like that, there are a lot of people who want to say, oh, I think I know this, or somebody told me that. And when investigators tracked those leads down, they typically came to a dead end. At the same time, Skylar's friends were not really saying anything different from what they had said in the beginning. So suspicions may have arisen and abounded, but we didn't really have a break until early in 2013 that was concrete. Well, I know that certainly it is one avenue of gaining information on the part of investigators to look at social media, just in the sometimes remote possibility that there might be something, there might be a grain of truth to something, or somebody really might be onto something, or a lot of times people will say ridiculous things on social media that totally incriminates them. So naturally police are smart enough to look in that direction, not in just this case, but every other case that you can think of. So clearly police were looking at those avenues as well.
Was there any, you mentioned, and with a smile, that people do say silly things that incriminate themselves. Was there anything on Miss Schoaf or Miss Eddy's social media that did that in this case?
I'm trying to think what some of their postings may have been. There was never anything concrete said by either of those girls. My recollection is that their expressions were, I'm so sorry, Skylar will miss you forever, things like that, that were totally meant to deflect attention, I guess. I guess I would only say that the right of allocution is a right to be exercised by a defendant herself, and so no one can force her to say anything, including an apology. Certainly from my own experience, I've seen defendants make apologies in that moment. Others pass up that opportunity. As to why she didn't, I can't speak.
Not accepted.
Maybe she thought that the statements by her attorney were sufficient.